Okay, so my name is Nicole Smith. I am the Event and Communications Coordinator for Spark Niagara, and we are so happy to be hosting this weekly webinar and having an incredible guest with us today from lawyersinhouse.com, and she will expand on what that is. We would like to first off acknowledge and thank our partners in this venture, which is South Niagara Chamber of Commerce, as well as the Niagara Falls Small Business Enterprise Center. So together we pull these things together, and we are so happy to do this. I am thrilled to have you join us. As I said, you are on mute. We ask that you please remain on mute to cut back on the ambient noise during the presentation. If you have any questions, we will be doing a Q&A at the end of it. We just ask that you please write your question in the chat box, and then we'll be able to address it at that time. If you wish to wait till the end to put your questions in the chat box, that is fine as well. So before I go on too far, I'd like to introduce Christine Holmes. She is with, as I said, lawyersinhouse.com. They are a very unique organization that are affiliated with us at Spark, and we are so excited to have you join us today, Christine, and I'm going to just hand it over to you.
Thanks so much, Nicole, and thanks to the Spark Niagara team and all the partners and sponsors. We're really excited to speak with you guys today and hopefully be able to provide some valuable information that will be worthwhile. We'll try not to make a legal presentation too painful. So a quick overview. I'll just tell you briefly a little bit about us and who we are, and then we're going to talk a little bit about incorporation, a little bit about contract basics, and then a little bit about expanding the team and what happens when you hire somebody. So I'm going to keep it pretty high level. One, because I'm hoping it'll be general enough that it'll be applicable to everyone. But as Nicole said, absolutely, please ask your questions. And I don't mean to rush through it, but I do want to make sure we have lots of time for questions, because I think there's a lot of value if you've got something specific. And usually when we do things like this, there are no stupid questions. And even you think you've got something really unique, it's very often is the case that there's other founders and other startups and scale-ups who have the exact same issue. So I look forward to the questions at the end, because I think that that's beneficial for everybody. So just a quick couple of words about us. So at lawyersinhouse.com, we are a full service virtual law firm. And prior to March of this year, that was really innovative. But now everybody's virtual. So it's really not that big of a deal. But we're also comprised solely of lawyers who've worked in-house. So what that means is we all have business practical experience. So we don't just sit in a law firm surrounded by other lawyers and say yes, no, but we've worked with companies, and we know that these companies, they have budgets, they have real timelines, and they have real things they have to make happen, even if they are risky. So our focus is, how do we help make that happen? We have an average of 15 years experience, so really experienced folks on our team. We're so lucky to have them. We are 100% woman-owned. 90% of our lawyers are female. 25% are Black, Indigenous people of color, and 25% were born outside of Canada. And this is a really big value statement and mission statement for us, because one of our main goal in starting this company, and we're a startup as well, we're just a year and a half old, is to increase diversity and inclusion in the legal industry. It is not a very diverse industry, as some of you may be aware, and it's 2020, and it's just there's no excuse for that anymore. So we're trying to create an alternative way for people to stay in the legal industry, maybe live in a rural area, or maybe balance family responsibilities if those are aging parents or kids. So that's what we're trying to create in our own industry. So that's just a little bit about us, but let's get to the important stuff. So incorporating 101. So I wanted to talk just quickly about corporate structures. So some of you, because I'm not sure, and I'm sure you are all at different stages, but often when people are just starting out, they're trying to figure out, do I register a business name? Do I need to incorporate? Do I have, if you've got partners, do you want to enter into a partnership agreement, or do you want to become shareholders and incorporate? I think that it's all really, just understanding where you are, and there's no real wrong answer. It's what's the best fit. So just want to touch on, what it means to register a business name. Does not make you incorporated and does not protect you or create that divide between your personal assets and your corporate assets. So it can have some value if you go to protect your IP or your trade name later. But really there's not a lot of legal or tax benefit to just registering your business name. Partnership, we're not really going to focus on that today, but if you have, as I said, a couple of people, the really key thing there, as I would say, is make sure, even if you're at the very beginning stages, make sure to have a partnership agreement. And if your partnership agreement deals with one, like if it has one section only, just make sure it's a dispute resolution section, because that's when everybody's going to pick up the agreement. So if you are in a partnership, you need to make sure, especially if there's two people, what happens if there's a disagreement? Who gets the deciding vote, or how is it going to be worked out? Because I've literally seen really great, creative, fun ventures come to a grinding halt because it was two partners, that of equal stance in the company and equal decision-making power, and they disagreed, and that was the end of the company. So just a quick aside on partnership agreements. So getting into incorporations. So really, I always say, if you're thinking of incorporating, there's two people you need to talk to. You need to talk to an accountant, and you need to talk to a lawyer. And don't let any lawyer tell you they're an accountant, and don't let any accountant tell you they're a lawyer. It's good to talk to both. So the accountant is going to come at it, obviously, from tax perspectives. What does it mean for you? What are the savings? What are the different write-offs that you can have if you were to incorporate a separate company? From a legal perspective, we're going to talk about liability. So we're going to say, what's the risk of what you're doing? And what we want to do is protect you and protect your assets. So when you incorporate, legally, you've created a separate entity. So something separate from yourself. Whereas if you're in a partnership or register a business name, or if you're a sole proprietor, at the end of the day, that's still you as a person. So what the separation does is it means any liability, any payments, any lawsuits, they go directly to the company. So for example, let's say you've developed an app. So you've developed an application. It's a SaaS platform that helps synergize some savings in a business process. So some companies sign on, you're making money, you've got some ARR or MRR, and then it gets hacked and they get access to some data. Or data's leaked. So those companies are now suing you. So if you're incorporated, they can sue the company bank accounts. If you're not, if you're a partnership or a sole proprietor, they would be suing you personally, which means, your house, your bank accounts, your RSPs, those types of things. So a lawyer is going to say that's the most important thing for you to think about. Now, if you're pre-revenue, if you're pre-product, so, some people are still developing a product, you might say, I'm not sure this is something I need to worry about right away. And the other thing that people will say is, do you need a lawyer to incorporate? And I'm hoping I'm going to surprise you all by saying, no, no, you don't. If you're pre-revenue, or if you're at the early stages and you're just going to see if this is going to work out, there are all sorts of online resources where you can sign up and you can incorporate yourself. And I'm going to talk about some of the key considerations to think about if you do that. But that average cost, I think, is about $400. I think in Ontario, for example, I think it's about $360 is the government fee to register. So a lawyer is probably going to charge you somewhere between $1,000 and $2,000 to incorporate. So I would say don't hire a lawyer. Don't spend that kind of money until you're ready to, and you feel it's the right time for you and your business. Because the other part of it is, if you go and you do it yourself and you mess it up, or you don't set it up properly, we can fix it. We'll fix it when you're ready. We'll fix it when you go to raise funds, or we'll fix it, if any kind of, you bring in a shareholder, we can always change that down the road. Now, with that said, a caveat, don't wait, 10 years for us to fix it. And then there can be, some serious consequences. But once you get up and running, just hire a lawyer to review what you've done and say, hey, is this okay? Or should I make some changes? So things you want to think about when you're incorporating, so that either the lawyer should be asking you, or if you're doing it yourself. Couple of key points. The first I'll say is jurisdiction. So do you want to be an Ontario company? Do you want to be another provincial company? Or do you want to be a federal company? And it's important to keep in mind that really it doesn't matter. If you register and become an Ontario company, that doesn't mean you can only operate in Ontario. There are slight differentiations through the province. So for example, if you're not a Canadian resident, BC is a province that actually doesn't require you to have Canadian directors. So one of the options there would be for you to incorporate in BC to get around that, whereas Ontario and most of the other provinces do. The only difference that I would say is to consider is, who is your target market? Who are you selling to? If it is global, I know a number of people in a school of thought is perhaps then you incorporate federally. Because I think if you're, dealing with someone in Asia or perhaps in Europe, let's be honest, they may not know what Saskatchewan is. So if you're a Canadian company, in some senses, that gives you, a little bit more, I don't want to say clout. There's nothing wrong with Saskatchewan. I'm just saying it's more recognizable in the global market. So that's just an opinion, but that's what I often see, or what we often advise companies to do. So, and then looking at, you'll see if you use any of the online resources, there'll be a whole bunch of different resolutions that you'll have to go through. Just try your best to go through, see what seems applicable to you. They're not all going to be applicable to you. And same with issuing shares. I would recommend you issue more than one share. That's the most common mistake we see for entrepreneurs starting a business when they incorporate themselves, is they incorporate one share and then they go to take on investors or raise capital, and you've got one share that you're selling. So it's probably, you want a bit more than that. Even 100 common shares is a great way to start. You probably don't need two different share categories. There's common shares and preferred shares. Again, we can build in that complexity when you need it. You may want that when you raise funds, but keep it simple. You'll go through bylaws, but I know it's painful, but read the suggested bylaws, read the templates, because sometimes you can be surprised things that are buried in there. There can be limits on raising funds. There can be limits on bringing in another shareholder. Just think of your vision for your company and read through all of that boring legalese and just see if there's anything that immediately could be problematic, and see if you can remove that. And then just keep track of everything, create a little minute book for yourself, and keep track of that. And then you've got it. You've got everything you need. You've protected yourself from a liability standpoint. You've, talked to your accountant about what it means from a financial and tax standpoint. And then as you start to grow, and as I said, if you have any concerns, always you can ask a lawyer to do a quick review and see if anything needs to be done. So that's just a quick overview on incorporating. So contracts, the basics of contracts. So the biggest thing I see or hear questions about, or usually the first document to come forward, either because you want it or your prospective client or partner or funder has asked for it, is an NDA, non-disclosure agreement. So are they necessary? When should you sign one? And should they be mutual? So I'll start with the easy one. They should pretty much always be mutual. So if you're in discussions with someone and they say, oh, hey, we'll give you company information, but so can you sign our one-sided NDA? Unless you're literally not telling them anything about yourself, you're not telling them about your product, you're not telling them about your pricing, you're not telling them about your go-to-market strategy, you should never sign a one-sided NDA. Always make sure that it's mutual. And one of the best questions I had on NDAs in a workshop like this that I did last year was a founder said to me, Christine, I can't afford if this company steals my IP. He was developing a product. He said, I can't afford to sue them. And, they've got lots of money. They can drag out the litigation. Like, I would just lose my product anyway. So why sign an NDA? So what we had said was, well, what's your end game here? Are you looking to raise capital, or will you be? Are you looking for an exit strategy? Are you thinking, I want to build this up and hopefully in 5 to 10 years sell it? Because if you are, the first thing an investor or a possible buyer is going to do is look at your product, look at what you have, and then they're going to do due diligence and look at how you've protected your intellectual property. And if you've entered into all these agreements with no non-disclosure agreements, nothing that protects your IP, arguably, what's the value of your IP? Now, if you've trademarked something or if you've patented your process, then you've protected it in another manner. But usually early on, that may not have happened. And the value of what you have is going to be greatly diminished because you haven't even tried to protect it. And you don't want, I have no doubt you all have really cool ideas that you're either in services you're providing or products you're developing. So protect them. So, and that goes into, when should you sign an NDA? As soon as you start having discussions. As soon as you get into substantial discussions where an NDA should be signed before you do a demo. It should be signed before you talk about pricing. As I said, go to market strategy. That's all yours. You've come up with that. So why not protect it as best as you can? And then talking about documentation generally, what do you need? Should you have your own template? Should you just use your customers? Sometimes that's a bargaining power. I'm not going to sit here and say, listen, hire a lawyer, spend a lot of money to develop all your own templates. And if you're marketing to very large companies, you're probably not going to get to use your own templates. They're probably going to say, here's our agreement, sign it or we won't do business. So that's always a consideration. But look at the different types, look at what you're offering. Do you want something like a master services agreement? So if you're providing services where you do a big agreement that covers everything, and then you say, okay, well, we'll enter into individual statements of work. So you can hire us for overall services, but then you need something specific, that's where we'll put the details of how many hours, how many people, hourly rate, that kind of thing. Or maybe you just need a little product purchase agreement, 2 pages of going through, reps and warranties, disclaimers, indemnities, looking at things like that. So really it's just obviously a SaaS agreement. If you've got a SaaS product, you do want to have the basic documentation in place to protect yourself and to have the key terms. And in negotiating that brings you and your customer on the same page. It's just like a partnership agreement. No one's going to pick up the contract until there's a problem. And then as soon as there's a problem, your client's going to pick up, or customer will pick up the contract and go, well, what does the contract say? So it's really important. You want the contract to say exactly the way things are supposed to go. So it's really just a matter of, what do you need for your business? The one thing is we get a lot of questions where people will ask about letters of intent, where they say, well, it's just faster and it's easier. Let's do a letter of intent. And then once we get this signed, then we'll do a full agreement. And my advice to you is not to do that, because you will find you will spend as much time and resources negotiating a letter of intent and then you're just going to get it finished and you're going to start, and then you're either not ever going to get that full agreement in place, which you need, or now you're going to start and have another full second negotiation. So your time is precious. You'd never have enough of it as an entrepreneur. If only you could clone yourself. So just, I would say, whenever anyone tries to say, well, let's just do something little and then something smaller, just have a scaled down template that you can use, that you can live with, so you don't have to go through the process more than once. So with contracts, asking the same question with incorporation: should you have a lawyer review your contracts? And I really wish I could say no to this one too, but I don't think that's in your best interest. So instead, what I wanted to do was give you some advice on what you should do before you call a lawyer to save you money. So see if you can find a precedent. Even if you're just Googling it online, SaaS agreement or whatever it might be, and you read through it, see if you can download it, read through it, see what makes sense for your business, what doesn't, and then insert the business terms. So take your precedent and say, okay, well, we're agreeing to, monthly recurring revenue, and here's how it's going to be paid, and here's the services we're going to provide, here's the term, customer full legal name. This is really important. So whenever you sign any document, an NDA, even a letter agreement, any kind of contract at all, it has to be in your company's full legal name, and it has to be in your client's full legal name. So if that client is a company, you have to have an Inc., incorporated, co, corporation, limited, or LTD. And if it doesn't have that, you haven't legally bound the company. So that's just a really big one I want people to look out for when they're entering into agreements. But I would say put all of that together, as much of that information as you can first. You know your business, you know it better than anybody else. Then call the lawyer and say, okay, here's what I'm going to send to you. And that lawyer should be asking you, okay, tell me about your business. Tell me about your product. Tell me about your services. Tell me about your go-to-market strategy. What are the biggest concerns for you? What risks can you live with? What risks can you not live with? How much insurance do you have? Because then we know where to cap liability, right? You shouldn't be capping liability higher than the insurance policies that you have, because then who's going to make up that difference if there's a claim? So all of these questions are questions your lawyer should be asking you, because unfortunately the templates you find all online are exactly that. They're not customized to you and your business. And that's where the value of a lawyer would come from, is knowing your business and then being able to walk you through all those dense, indemnities and warranties, to make sure that it says exactly what you need to protect yourself. So make sure your lawyer is asking you those types of questions and understands your business. That's really key. Okay, and so moving on, so to hiring, the exciting and daunting process of expanding the business, right? So do you want to bring on employees? Do you want to bring in contractors? Obviously, there's plus minuses of both, and they're treated differently. So obviously with employees, they're governed by the different provincial and federal legislation. There's payroll deductions. Typically, those are exclusive relationships. Sometimes you could have a part-time employee that has a part-time engagement elsewhere. And then if that person leaves, or not if they leave, if you ask that person to leave, there's going to be termination pay. Contractor, obviously a lot less resources put into onboarding and offboarding, because there's no payroll deductions that need to be calculated. There's no vacation pay owing to them. If you part ways with them, it would be based on contractual terms. So there's no termination pay owed to them. It's a lot of flexibility. It's a great way for a young company to either bring on people maybe that it couldn't afford full-time in a lesser capacity, or to work with fluctuations, to bring somebody on for a certain period of time, and then you're going to have a slower period. And it really helps with labor and cash flow fluctuations. The problem with bringing on a contractor is the risk of reclassification. So And what do I mean by that? There's two people, two entities that will reclassify your contractors. And one is our great friends at the CRA, who every company, big and small, loves to deal with. And the second is the Ministry of Labor. So they both have their own tests. They're really similar. I've put them both up here, but as you can see when you go through them, they're really similar, that they look at. So it doesn't matter if you entitle your agreement employment agreement or you entitle it independent contractor agreement with that person. They're going to look at how you treat that person. They're going to look at how that person operates. And really one of the biggest things is control. So the level of control that that person has. So basically, can they say, you know, I'm not going to be available for 2 weeks next month, just so you know. And, oh, well, I will come into the office and have a meeting on Monday, but, you know, I can't on Wednesday. Whereas, as you know, with an employee, you would tell them you get 2 weeks or 3 weeks of vacation a year. If there's a meeting that they need to go to, you expect them to be there. You manage them more. They have a lot less control. Another thing they will look at is ownership of tools. So if you bring somebody on and you say, okay, well, here's a company phone, here's a company laptop, here's, you know, our policies, this is a really common mistake where you say, here's our employee handbook. I know you're not an employee, but here's our employee handbook for you to follow, all of our processes and policies. CRA and the Ministry of Labor will look at that and say, that's somebody looking more like an employee than a contractor. They'll also look at the chance of profit or loss, or the opportunity to profit. So other than employees, obviously in sales, you know, might have commissions, or there might be bonuses. But what they really mean here is with a contractor, where you can really increase your time and then you go up to a greater pay scale, or the more money you make for the company, the more money you make as a person. You know, it's not the case that if, let's say you're a sales employee at a company and you bring in 4 times the revenue, your salary isn't going up, you know, by 4 times. So they're looking at that kind of, again, I always think it comes back to control. And CRA also will look at the intentions of the parties. But I'll be totally honest with you, they say they look at that. But if they do, they certainly don't weigh it very highly, because then they'll just make their own determination. And then one of the things that the Ministry of Labor looks at, which CRA will too, because again, it goes into control, is if the worker has the ability to hire people to assist them. So when you think about it, if you designate a certain amount of work to an employee, that employee can't then go hire somebody to do that work. Whereas if you hire an independent contractor, they may turn around and say, well, I'm going to hire an admin to do a certain portion of this, or I'm going to subcontract a certain portion of this out. So as I said, I really feel it does come down to control and the tools that they're given. And unfortunately, you know, if you end up on the wrong side of this, it is back pay for all of the source deductions you should have been taken from the independent contractor. There's fines, there's penalties, and the worst part is probably the, you know, being flagged by CRA. And then they're always watching. And it really is too bad, because we literally have a client who hired a 3-month contractor. And CRA came back and said that was an employee for those 3 months. And they didn't hire counsel or anything, but they just tried to fight it themselves and lost. So they ended up having to pay. Now it was a short amount of time, but they ended up having to pay back pays and then a small fine. So that's the tough part. So you really want to make sure you have your independent contractor agreement properly worded, so that you know, there's no restrictions on them. You could restrict them from directly working with one of your competitors, but other than that, really don't try to put any control over them, and then watch how you're treating them. And that can be the hard part, because often we say, well, we want to treat them like part of the team. We want them to feel like everybody else, and we want them to feel valued. And you do want them to feel valued and make them feel, as they are a key member of the team. But if they come to all team meetings, if they have to report to you the same way that your employees report to you, as I said, it's an employee phone and computer they've been given. They're not hiring other people, especially if they don't have any other companies they're working for. They really are starting to look more like an employee. So just a heads up on that one, because I find that's one that can be costly if it trips people up. So that was and I'm sorry to go so quickly, but as I said, I just wanted to give a general overview, and then really hoping we could get into some questions based on that, or some deeper conversations in areas that are relevant to you, as opposed to me babbling on about things that maybe not be a great fit for you.
Well, Christine, that was all amazing. Such great information. Wow. Yeah, questions. Definitely. There's been some questions that have been posted as you've been speaking, and I've written down a few of my own. But the very first question is, what city are you located in? So I'm assuming that they mean lawyersinhouse.com. So where is that located?
Oh, perfect. Well, great question, Tim. Yes, I just see that. So we're virtual. So we are basically everywhere. So me personally, I'm in Muskoka, but we have lawyers across the country, and we actually have lawyers in the US, in New York, Illinois, and California. Lawyers called in England and Wales, and we also have lawyers called in the EU.
Fantastic. And that's important to realize and to know. So there's no bricks and mortars. You're literally, if they reach out to you, it's all online, which is, in this world right now, is perfect.
Exactly. Now, with that said, we do, in the before times, we would meet people, or, come to offices and do those kinds of things. And hopefully one day we'll be back to that soon.
That's what everybody's thinking, I think. Okay, so we're going to move on. There are a few more other questions. So we have a question from Patrick. His question is there anything that must be included in a minute book legally, or does each business make up their own template?
Great question. And it's probably good you would want all of the basics are your articles of incorporation, your bylaws, so all of your constating documents, all of your resolutions, and then minutes of whenever the directors meet or pass any motions, and then any further resolutions. So for example, your bylaws may say, let's say there's two of you in the company and you've incorporated, you're both shareholders, you're both directors, and your bylaws may say you have to have unanimous directors agreement to raise capital. So you would then need to do a director's resolution that you write that out and you both sign as directors, and that's what you would put in the minute book. So it's all of that. So when you go to raise funds, or when anyone's looking to purchase, they would go back and everything, the key decisions you've made and all of those materials and documents would be there in the minute book. But just so you know, I don't know how many times I've ever come across a minute book that has everything it should. So it's a tough thing to keep up with, but those are the basics of what should be in there.
Okay, fantastic. That's great. We have a question from Tim Hauser. How do you know if their business is actually a legal entity? How do you verify that?
Great question. So you can search, and a lawyer can certainly search as well. But you would be asking for that full legal name. So it's like if you came to us, like lawyersinhouse.com, so that's not a legal name. So if you entered into a contract with me and you saw lawyersinhouse.com, you should be coming back and saying, well, what's your legal name? And then I would say it's LIHDC Professional Corporation. It's a little bit different because we're lawyers. But if I was a company, I should say it's lawyersinhouse.com Limited, or lawyersinhouse.com incorporated. And if they're not giving you that information, they either don't know what it means or they're not incorporated. And then if they give you a company name, that's something that you can search on, and we can do a nuanced search. But I'm pretty sure you don't need any special government registration to go on and do those searches as an individual.
Okay, that's great. Now, Ankit is asking, before signing any NDA, are there any red flags we should look for? Should we have it reviewed with a lawyer, or can we review given that we are a startup?
Great question. You know, and it's tough. I always like to have, if you know the basics of the NDA, then, you know, you go ahead and sign them. Or maybe what it is just a first conversation with a lawyer to understand the basics of an NDA, so you feel that you know what you're agreeing to. Some of the big watch-outs are that the definition of confidential information. So one, making sure, because sometimes you get these companies, let's say you have a platform, a SaaS product, but you're dealing with a company that's not a technology company. So that definition might not include things like algorithms and, you know, things that are specific to your business. So make sure that the definition is all encompassing. So the actual information you're exposing is protected. But my really big watch out is that when they say, well, one is the term, because sometimes people will say, like, we hold it confidential for a year or two, you know, and I always say to people, well, you know, if someone knows your go-to-market strategy and your pricing, like, do you really want that? You know, especially if you give them demos and like, do you really want that just to be held confidential for a year? Like, I would think there'd be more value in it than that. So I push it out as long as I can, 3 years, 5 years. Sometimes you can get in perpetuity. Some of the information will change. So you think, okay, 5 years down the road, I probably have different pricing. I'll probably go to the market differently. But still think about term. But the biggest watch out, in my opinion, is when you have, and I see it all the time. And in fact, we just went back and forth for like 3 months with one company dealing with Siemens, because Siemens standard NDA says what is considered confidential information is anything marked confidential. And I don't know how you guys run your business, but I mean, even as a law firm, there's a whole lot of information that gets passed through email, over the phone, that is not marked confidential. And you really don't want that. You don't want that risk of it has to be stamped on there. And then the other thing is you show them a demo. Well, where on the demo is it marked confidential? And how do you prove that when you showed them the demo, it was marked confidential in that point in time? Like, there's all sorts of logistic problems with that. So that's a really big watch out, I would say, for NDAs, is make sure that it doesn't say, you can have that, but then say anything marked confidential, or that a reasonable party would deem to be confidential information, if that makes sense.
Yep. Fantastic. Thank you. Thank you. That was a very comprehensive response to that. That's great. Thank you so much.
That means I'm talking too much.
Oh, no, that means you're describing a lot and you're giving us meat, and I like that. So we have a question from Michelle. She says, I run an outdoor adventure business geared to women. Is it discriminatory or a human rights violation to deny men our services?
Have you had a complaint? I guess she probably can't answer that in real time. Or
Well, if you need the answer, Michelle can unmute herself to answer that question. Michelle, if you wish to unmute yourself, feel free to do that. Is she still here? Oh, there she is. Oh.
Hi.
Hi, Michelle.
No, I haven't had any complaints, but I've had a few women who wanted to invite their husbands and boyfriends. And you know, I don't mind so much, but it's just I've geared the whole business around empowering other women. And I don't want the other women that come on these tours to be feeling uncomfortable that there are men in the group.
It's a really great question, Michelle. First of all, it sounds like a great business. Congratulations. And it's hard not to feel like this is a double standard, because as we know, for traditionally, it's been male exclusive clubs, male exclusive industries. And, we've had to fight tooth and nail to get in there and get representation. And we said, hey, that's exclusive. That's unfair. And has been a human rights claim. So when we do something that's specifically for, in this case, one gender and not the other, it is possible that you're opening yourself up. The argument is that this is traditionally an underserved group, that there are opportunities for men to do this. Whether it's in a co-ed atmosphere or just on their own, and perhaps maybe having some of those resources handy to point people towards.
Yeah.
So that's how, your response is great. You're trying to make everyone feel comfortable, and people have signed up thinking it's going to be female only. But those are kind of the arguments that I would say I would put forward, and making sure that there are opportunities for them. Yeah.
Yes. Okay. So yeah, I have thought of opening up some activities for couples, so that it's labeled for couples, and then having other activities labeled for women.
Exactly. And that would be perfect. And that would be a great, because I'm sure your intent is not to discriminate. Your intent,
that's right.
Yeah, your intent is to empower one group who traditionally may not feel as empowered if the other gender is there.
Yes, exactly. Yes.
Yeah, I think that would be a great defense, actually having another program where they would be welcomed.
Okay. Okay. That's great. Thank you so much.
You're welcome. Great question.
Thank you, Michelle. Okay, we have a question from Valerie. She is saying, I run a home-based bookkeeping business. I do bookkeeping and tax services. Should I have my clients sign a contract before I do work for them?
Great question. I would definitely have them sign something. I don't know if you have anything in writing, but I would say you would want things like what the fee is, what the rates are, that you would hold things confidential, for example. But also, I would think it would make sense for you to have some language in there protecting yourself if, for example, the CRA comes back at them or audits them, or that's not on you. You don't want them to be able to come back to you and because of any of those issues, barring your own gross negligence, which I'm sure isn't the case. So I would think, and again, it's just about expectations. So that no one turns around one day and says, oh, well, this isn't what I was expecting to happen. So I would recommend it. Personally, doesn't have to be anything big, probably something you can do in a 2-pager, or even just depending on the font, maybe 1 page, and just something that you can get some basics. That so everybody understands the process and the payments and what's expected and what you're providing and what you're not, which is, guarantees, right?
Perfect. Well, thank you. Okay, now a question from Sherry. Do you know any good resources for contract templates like SaaS agreements, NDA? Also, what would be a reasonable price to get the SaaS agreement customized, finalized with a lawyer?
So what I would honestly say is Google it. Google it. And the first ones that are going to come up is like all these things you have to pay for. But don't do any of that. But go through and find all of the big companies, Amazon, Google, all of those, you can find their terms and conditions online. So go and, if you take a look, think of other SaaS products that you've dealt with and see where their agreements are. So much of that is online. So that's where I would start, is by seeing what you can find out there on the internet. which is probably a really funny answer for a lawyer to say, but that is where I would start. And then take a read through. And that's what I was saying when we were talking about contracts is do that, see what you can find, you read through it from your business perspective, get some things together, get your terms, try to come up with it yourself. You're all obviously very smart people, and come up with what you can, and then take that to the lawyer. Because if you go to a lawyer and say, can you develop a SaaS agreement for me? And then they're going to say, okay, well, tell me about your business. And then you're going to go back and forth, and they're going to create a draft, and then you're going to review it. And then there's going to be more questions and more back and forth. You're probably, I would guess, in the 4 to 5 hour range. If you call a lawyer and say, here's my template, here's my documents, can you just take a read through and give me some high level watch outs? You've cut that time in half for sure. And most lawyers bill by the hour. And the other thing is to ask if they'll give you a set rate. Like, don't be afraid, call them up. Our highest hourly rate, because we're virtual, so I always say we don't have 4 floors in the TD Tower that you have to pay for, right? So our highest hourly rate, for example, is $3.25 an hour. So but we have, especially startups and entrepreneurs, come to us and say, I've got $700. This is what I need. What can you do for me? And business-minded lawyers are going to figure that out. So you can get what you need, and we can help you within your budget.
Fantastic. The next question is somewhat similar, but has a different flavor, I think. So it's from Sarah. Do you know any free resources online for contracts for basic tech subscriptions for SaaS companies that you would recommend? And do you think we would be okay to do this and then get something more official once we have multiple clients and have decided to pursue it fully? Still testing the idea.
That's a tough one. And this is where I can, show my, wave my white flag as a lawyer. Because I worry about entering into contractual agreements with clients, even when you're just starting out, that you haven't had any legal advice on. Because even if you say, okay, well, I'm just going to do a few clients, I'm just testing it. But what if something can go wrong with those few clients? And there's lots of liability that can happen. There's lots of, depending on it, like I said, is there data, that could be breached? Is there, personal information that can be breached? There's just some things that I think, honestly, it's if you take those steps, get the precedent, put it in a great form, and send it to a lawyer and literally say, I've got $500. Can you please just read as fast as you can and tell me if this is okay for where I am right now? It would be worth it, as opposed to finding out or something happening and you not being protected.
Okay. We have a lot of questions to go through, and we're running short on time, so we're going to try to get through these as quickly as we can.
Okay, so I'll talk faster.
Okay, so another question from Tim. How do you deal with any do you deal with any labor issues with workmen or workers going out on sick leave and not able to return to work, and you have to let them go? Can you do this during pandemic times? What should be a payout if only 2 years there?
So you tell me I have to speed up. There's lots of questions, and then you ask me a really complicated question.
This is
This is a tough one. In short, we do employment matters for sure. This is a tough one. The pandemic's tough for everybody. Let's be honest. It's tough for businesses. It's tough for employees. Most employees are trying to do right. Most employers are trying to do right by their employees. But this is a real factor. Sick leave is always a bit of a watch out, letting someone go on sick leave. You want to be a little extra careful there to show why you're doing it, and it's not because you're discriminating against them. because they have some sort of an illness, because that's your classic demand letter from a lawyer you're going to get when you let them go. So really, and the biggest thing I always say on how you treat your employees at the end of the day is the courts, not that would ever get to court, it'll just be some nasty letters back and forth, or should be, hopefully, or dealing with the ministry. They're always going to look at your actions. They're always going to look at your intent. You know, have you done the right thing? Does it make sense? Is it that, you know, you don't have a job for this person to come back to? It isn't because they're on sick leave. You actually feel really bad about it. And when you gave them termination pay, you were very fair. And you know, when you treat your people really well, and you always, of course, abide by the laws, but go over and above, and the courts or the ministry will look at that, and that matters. As far as the COVID piece, it's really hard to tell. It's really hard to tell what the courts or the ministry, how they're going to interpret all of this stuff, because it's a pretty tough situation. In some cases, people are saying, well, companies should pay more because you let somebody go. It's going to take them way longer to find a replacement job in this environment. But the flip side of that is companies are letting people go because there's no work and there's no money. So I would really judge it based on your actions and how you treat, how you document it. So that you can show this isn't about the person, this isn't about the sickness. You're just trying to do the right thing.
Okay, that's a great answer. Okay, so a question from Goldie Ruth. I will be dealing with vendors and small artists to rent my event space, storage, and table display space. I was going to write up membership style agreements that include monthly payment plans and consignment based on client needs. Would it be a good idea to talk with a lawyer to discuss the risks involved in this situation?
I would say yes. I would say you would want to, again, put all of your stuff together so it doesn't have to be a big, long, drawn out process with a lawyer. But again, it's your business, right? And it's worth protecting.
Fantastic. Okay. And a question from Patrick. How do companies hire their first employees in the very early stages if revenue can change month to month? If you agree to hire someone full-time and the revenue dries up for an unexpected reason, what does a company do?
Well, and this is the issue where you say hiring a contractor is easier, right? Because you can hire a contractor for a limited amount of time. Now, you can do that in an employment agreement. You could bring an employee on and say, I'm hiring you for 10 hours a week, if you know that that's what you can afford. Things to look at. If you let that person go as an employee, if the money dries up, you're going to owe them. Minimally, what's under the Employment Standards Act, if they're in Ontario, it's generally the same in every province. So about a week a year of notice. So if they've been there a couple of months, it's another week's pay. But that's when they could get a lawyer and ask for a little bit more. So you want to be careful, and you especially want to be careful if they're leaving a job, a full-time job to join you, and you look like you've really talked up this position and said, listen, like, we're really going places, which I'm sure you will be, and it's what you hope. But if there is an unexpected term, the courts will look at that as you enticing them. And they're going to turn around and say, I had this full-time job. I was there for 5 years. I'd still be there if you hadn't lured me away. And then you're looking at more liability. Often what the courts will do is they'll add on the years they were at the company to the amount of time they were at your company, and then that's how much you have to pay for. So your 1 week would all of a sudden go to 5 weeks that you would owe them, if not more. A lawyer will fight for more than what's written in the ESA. A lawyer will go for anywhere from 2 to 4 weeks per year of service.
Wow. Okay, that's a great answer. And we have one final question from Ankit. When two entities entering into a contract are in different geographic regions, do we have two agreements pertaining to the bylaws for each region, or just a common based on the commonality?
Bylaws? So is she saying two different entities are the shareholders? Are the entities the shareholders, or is this a business contract? Perhaps does she mean contracts and each party's in a different jurisdiction?
Yes, that's exactly what it is. Is that you, Ankit?
Ankit?
Yeah, that's me. Hey.
Hi, Ankit.
Hey. I just meant by entities, I meant two companies who are trying to get into like a service agreement or like a contract, like a service level contract. And if they are located, like one is in US, the other one is in Canada, if they might have different laws pertaining to the agreement, how do we just spin up one contract between the agreement, or do they have their own individual ones based on which region they belong to?
That's a really, really great question, and a really important question, because one of the biggest things that should be in your contract is jurisdiction. So that, or governing law, you'll often see it called the governing law. And the contract you should enter into, it's just one. You should just enter into one agreement. That's the easiest, Ankit. And
Okay.
and it should be, and you have, now you have to pick a place. You know, so, and that's, that this becomes part of the negotiation, kind of like price. So if you're a Ontario company, I would urge you to make sure all your templates say the governing law is Ontario.
Okay.
And then now, you know, if you're dealing with a larger company and they say, no, I want it to be New York, or I want it to, here's my tip. If it's a US company, especially if you have any kind of SaaS product, but I would recommend, recommendation for US law is always go with Delaware.
Okay.
If you have a SaaS product, just so you know, the state of New York does not recognize auto renewal agreements. So if you have a 1-year term and then say it will automatically renew, the state of New York doesn't recognize that, and they will consider it done after 1 year. So I'd recommend Delaware, but it's always a negotiation point. You know, anywhere in Canada is better than anywhere outside of Canada.
Gotcha.
And what you'll often see, what I've seen in negotiating with Asia, for example, or South Asia and Canada, is sometimes they'll agree to the law of England. You know, because many of us are common law countries. And that's kind of the common law mothership. So sometimes that's a general basis as well. But it is an important question, because there are different laws that could impact you in a way that you don't know.
Gotcha. Okay. Awesome. Thank you so much. Thank you so much.
Thank you.
Okay, thank you so much, Christine. And that was our last question. Although we do have a request for contact information. So I guess, are you willing to have your contact information shared?
Yeah,
with?
sure. Absolutely. Yeah. Happy to answer any questions. And I know it can feel daunting. And one thing I would like to say is, you know, I have no doubt you're all really smart, capable people, but I'm guessing none of you are lawyers. So don't ever feel like you have a stupid question or you're supposed to know this stuff. Like, I don't know how to build a SaaS anything. I don't know how to build an application or build a platform or do what you do in your business. So don't expect yourself to have this knowledge, and don't feel in any way intimidated because you don't. You're all still very smart people, and make sure no lawyer makes you feel that way. You know, you should feel very comfortable and knowledgeable in asking these questions and making sure you get, you know, some really great answers that are specific to you and your business.
And that concludes today's webinar. So thank you again, Christine, for everything. Thank you, everybody, for coming, and I hope you have a great rest of your week.